It's really difficult for the public to trust what a judge is doing when the judge makes their decisions behind closed doors. I wouldn't let my ego get in the way. There's no reason to let your ego get in the way. That person probably shouldn't be on the bench. It's okay to be wrong. It's okay to change your mind. When I describe myself as being humble, I can be wrong. I can change my mind. But that doesn't mean that makes me a weak judge. I think that actually would make me a stronger judge. It's so important to make sure that what the judge's decisions are made public, and how that judge makes that decision is made public.
Hi, I'm Emily McFarling, and I am here with attorney Kerri Maxey, who is running for Family Court Department N. Welcome.
Thank you for having me.
So, Kerri, why don't you tell us a little bit about yourself?
I am the daughter of divorced parents. My parents got divorced when I was young, and it was a very bitter divorce. It affected me as a child, and it still affects me today. My father refused to pay child support, and so my mom got sole physical and legal custody of me. And when my father refused to pay child support, I found myself with my mom living paycheck to paycheck. She, about 3 winters, she heated the house with the oven because she couldn't afford to get the furnace fixed. My mother never forced visitation. My dad never asked for visitation. And I lost my father. He passed away when I was young. I have always wished that there was a judge that would have forced visitation, because that would have hopefully created that father-daughter relationship that I never had. I put myself through school. I worked as a housekeeper at a railroad lodging. I delivered pizzas, I made sandwiches at a deli, and I was a cashier at a gas station. I am a public servant. I have dedicated my practice to giving back to the community by working for the Public Defender's Office and Legal Aid Center of Southern Nevada. I am a union member. I have served as the president, the vice president, and on the board for the Clark County Defenders Union. I also helped write our original contract with the county and negotiated that contract. I am a widow. I'm not a mom, but I am an aunt. I have 4 nieces, 3 nephews, 1 great niece, and 1 great nephew. So literally and figuratively, I'm a great aunt. I am authentic, I am humble, and I am kind.
Why did you decide to run for Family Court?
About 2 years ago, the seed was planted. There was a decision that a judge had made, and I was really upset with that decision. I felt the decision was not in the best interest of the child. I felt the decision also jeopardized the safety of the child, and I had a lot of heartburn over this decision. I was at a team meeting, and I was complaining about the decision to my team. And my team lead told me to stop complaining and to run. And then the rest of my teammates just jumped in and started telling me how great of a judge I would be, and that we need people like me on the bench. So that seed was planted, and 2 years later it has grown, and here I am running to make those tough decisions, those decisions that need to be made that are in the best interest of a child.
And what are your judicial goals?
I have 3 judicial goals. The first goal is to put the child first. It seems like these judges get so wrapped up with the parents that are in front of them that they forget that there is a child in the courtroom, a child that is a person, has feelings and a voice. And if elected, I will make sure that child is put first. And not only will I listen to that child, but I'll hear that child's voice. My second goal is transparency. It's so important to make sure that what the judge's decisions are made public, and how that judge makes that decision is made public. It's so frustrating when you file a petition or a motion, and then your petition and motion gets decided through a minute order and you don't have a hearing, you're not allowed to make a record. It's so frustrating. So if elected, I will not only be transparent, but I'll make sure that those hearings are held, people are allowed to make a record, and I have nothing to hide. You will know exactly why and how I make my decision. My last goal is empathy. A family going through the family court system is a family in crisis. And the bench needs to take that into consideration and needs to remember that these families need to be treated with kindness and respect. And that's my third goal, is to ensuring not only that the bench treats the families that are in crisis with respect and empathy, but each party in the courtroom also treats each other with respect and empathy.
And how can we restore some trust and confidence in our court system?
Well, that's one of my goals, and that would be one of the things is transparency. Again, it's really difficult for the public to trust what a judge is doing when the judge makes their decisions behind closed doors. So my doors will always be open, and I will always make sure that my decisions are not only made in a way that you understand how I make my decisions, but on with a record and a good record, so that there's transparency. The second way to ensure trust with the public on the judiciary bench is protecting a person's due process. It seems like a lot of people are not getting their day in court. Their voice is not being heard. And I would make sure that each party's voice is heard, and that policy and procedure doesn't silence that person and doesn't take away that person's day in court.
What are your views on a child testifying in a child custody proceeding in family court?
If the child is old enough, they should be able to testify. That's one of the factors that a judge must consider in determining custody in the best interest of a child. How that child testifies, there's several avenues, and you need to take each child separately, each case separately. I wouldn't have like a blanket rule of how a child's going to testify. I would take each case individually and treat it individually and make that decision based on how best that child's voice will be heard.
So, what will you do as a judge to reduce the cost and the stress of people having to have a case in the Clark County Family Court?
I can't change the system, but I can control the cases that are in front of me. I understand how traumatic it is to be in front of a judge, not only for the adults, the parents, but also for the child too. So I think it's important to make a decision that is clear, concise, has no ambiguities, so that you don't have to keep coming back to court. You know what I have decided. Streamlining cases too could also reduce costs. So I would take each case individually and do my best to make sure that not only they have their day in court, but hopefully make it so that you don't have to come back to court.
A lot of custody cases involve somebody requesting to move out of the state of Nevada with the party's minor child against the objection of the other parent. How do you look at those cases? What's the most important thing to look at in those cases when you're looking at a final order for it, but also if somebody's asking to move right away before you actually have the opportunity to have a full evidentiary hearing to make a full final decision on it?
Again, I think each case has to be taken separately and individually, and you have to look at all the facts. I can understand when there's situations where the move for the parent is imminent because they could lose their job. And if they lose their job, then they would not be able to provide the basic necessities for the child. So that I can understand if it's an emergency situation, you would have to allow that to happen before an evidentiary hearing. But again, I wouldn't want to have a blanket rule. I would take each case individually, each case separately, and apply the law correctly to each case.
Do you have any concerns that if you do allow somebody to relocate with a child on a temporary basis, and then once all the evidence is actually heard at the end of the day, you might make a different decision? Do you have any problems with making a different decision when you've actually already allowed a parent and a kid to move because of some kind of urgent situation?
No, I wouldn't. And that's the tough decisions that a judge has to make. When you have a case in front of you and you think temporarily that the move is good for the family and the child, but after you hear all the evidence and you realize that now for a permanent move, it's not in the best interest of the child, you have to make that tough decision. And I think it would also be appropriate for the judge to warn all parties that this is a temporary decision, and this temporary decision can change depending on the evidence that's presented.
Sometimes in our family courts, judges in my experience in family court, sometimes judges will get, once they've made a decision, their ego or something makes them want to, let's just keep doing what we've been doing, or I couldn't have been wrong in the past, or, what are your thoughts on how you would handle cases that, as you get more information, maybe what's best in that case might be different?
I wouldn't let my ego get in the way. There's no reason to let your ego get in the way. You're on the bench. You have a job to do. You need to protect the child's best interests. You have a family in crisis. And to allow your ego to prevent you from doing your duty and to prevent you from applying the law correctly, that person probably shouldn't be on the bench. It's okay to be wrong. It's okay to change your mind. And that's when I describe myself as being humble. I can be wrong. I can change my mind. But that doesn't mean that makes me lesser of a judge or a weak judge. I think that actually would make me a stronger judge to be able to change my mind and recognize any mistake that I made.
I appreciate that. Tell us a little bit about your background in dealing with financials. A lot of family court proceedings deal with dividing assets and divorce, so it's something that's important for a judge to have a background in. What's your background that relates to finances?
Oh, well, I graduated from UNLV with a bachelor's in economics, so I do understand math, and math doesn't scare me. One of the many jobs that I had when I was putting myself through school was I was the office manager for UNLV's student newspaper, the Rebel Yell, which means I had to do their payroll. I had to do their accounts receivable. When I was a cashier at a gas station, I moved up to be manager. As the manager, I was in charge of inventory, buying inventory, and making sure that all that finances matched up. When I was on the union as the board member and the president, negotiating our contract with the county, I looked at the county's budget, and I would have to go through the county's budget to determine whether or not the COLAs we were asking for was reasonable, or when the county was telling me no for our raises that we wanted, I would have to go through their budget. And I'm like, no, you can't afford our raises. And finally, representing kids in guardianship, we have a lot of estate guardianships. So I would have to go through their estates, make sure their estate is intact and protected. And if there's any misappropriated funds, then petition the court to get those funds back for the child. So I'm comfortable with finances, and I believe I can be competent with finances too.
Wonderful. What distinguishes you from your opponent?
I think there's three main things that distinguish me. First of all, being a public servant, I've only represented those individuals that nobody wants to represent. I take the cases that nobody wants. So I don't get to cherry pick my cases. I don't get to take the cases that are always winners. Second of all, representing kids, I have visited my minor clients in their homes. I go to their homes. I see where they live and how they live. I don't think my opponent has ever done that. And finally, empathy. I think that's the biggest distinguishment I have is I have empathy. I can always find something redeemable in somebody.
Are you aware of some cases that your opponent has presided over that are concerning to you?
Yes, I am aware of some cases. I can name 4 cases. The first case, all of the cases are just concerning. The first case deals with a transgender child. My opponent ordered a mother who was supporting her transgender child. He ordered the mom not to call her child by the pronouns that the child identifies. The child identifies with her and she pronouns, and now this mom is no longer allowed to call her own daughter through her and she. Also, my opponent ordered the mother not to allow the child to wear the clothing of her choice. She wants to wear dresses, but now the mom is no longer allowed to buy dresses for her own child and allow her child to wear dresses.
And we'll get to the remaining 3 cases. Following up on that first case that you just mentioned, what are your views as to the role of a family court judge in their own views on how to raise a child and the orders that they make for a parent and how that parent has to parent their own child?
I think that goes beyond the role of a judge. A parent has a constitutional right to raise their child. And that parent there's certain things the parent must be suitable. You have to provide all basic necessities, an education, medical care. As long as the parent is suitable and taking care of the child, who is a judge to say how a parent raises a child? That's the parent's decision. So for a judge to step in and put their own views of how to raise a child upon a parent, I think goes beyond the scope of being a judge. I think it's abuse of their discretion, honestly.
So tell us about the second case that you're aware of.
The second case dealt with a custody case between a mom and a dad, and my opponent, he ordered one parent, the father, to have the younger sibling and the mother to have the older siblings. So he separated the siblings. But the problem is there's 2 problems with that. First of all, separation of siblings shouldn't happen because you're destroying the sibling bond. But the separation between the parents, it's not like dad lives in North Las Vegas and mom lives in Henderson. They live in 2 different states. So the likelihood of these children having a sibling bond is almost cut. It's null. It's not going to happen. And then on top of it, the father has documented child abuse, which my opponent would not consider and refused to consider. So he granted a parent with documented child abuse a child and put that child in danger, possible harm. So that's the second. The third case is a writ that was filed, and the Nevada Supreme Court held that my opponent abused his discretion. And this writ was filed within the beginning of my opponent sitting on the bench, which is extremely concerning for a judge to have a writ filed so early while you're on the bench. The writ stated that my opponent abused his discretion because he failed to consider domestic violence when ordering temporary child custody, temporary physical custody, and that not considering domestic violence, again, domestic violence affects the child. It affects the child's brain development. It affects the child's relationship with other people in the future, and not to consider that and just to ignore it, that's dangerous. I believe that's really dangerous. And the last case dealt with finances. There was a husband who was alleging that his wife had hidden assets, and all he wanted to do was be able to participate in the discovery process and try to find those hidden assets. But my opponent ended the discovery process early. He ended it so that the husband was not able to determine and provide evidence to the judge that his wife was basically stealing from him. So by ending that process early and not allowing the husband to partake in discovery, he basically signed off on this wife from stealing from her husband, if that was true, but still, he basically signed off on transparency. That would have helped with these decisions coming forward and the public knowing about it. These decisions aren't, the public doesn't know about it because they're not open, they're not out there. I've known about a couple of the decisions because people are coming to me and telling me their stories. And so I'm very thankful that not only I can share the story with you, but I can also share it with your viewers too, because I think the viewers need to know.
And what else would you like to say to the voters of Clark County that we haven't discussed already?
I have been practicing law for almost 20 years. I have 19 of those 20 years, I have represented children. I have represented a child in delinquency, dependency, guardianship, and some custody cases. I have protected their constitutional rights, their legal interests, and their voice. I have been a champion for children. If elected, not only will I be a champion for children, but I'll be a champion for our Nevada families that are in crisis. You have a choice. You can choose. You can choose to elect a champion, or you can choose to elect status quo. Thank you.
Thank you for coming today. It was very nice meeting you and having this discussion with you, and hopefully we've given some good information to the viewers for this upcoming election in November for Family Court Department N.
Thank you. Thank you so much. Thank you for having me.